Okay. Beginning of life and end of life issues, according to the American Supreme Court. All right, so moving forward from the 20s, the first case that's really important is Griswold versus Connecticut. Now, I should say, I am not trying to espouse any particular beliefs or belief systems about these issues. What I'm trying to show you is what the American public has said via the Supreme Court and how other parts of the public have reacted. I'm just trying to open that conversation so that you have a sense of what your beliefs are versus what the law says, and all of those. You can start kind of thinking about those kind of things. It's just, I'm trying to open the topic, not tell you how to believe about it. Okay, so I want to say that there are a bunch of other cases outside of the ones I'm going to show you. There are dozens. But these are the biggies, okay? So first one is Griswold versus Connecticut. In 1965, a woman and her husband they're married. They decide that they don't want to have kids, so she goes to her doctor for birth control pills. And he says, I'm Catholic. I don't have to give you birth control pills, and I don't want to. And she says, I want them, and my husband and I have decided that we don't want to have kids. And he cites this law, which is identified as what's called a Comstock law, passed by a guy named Comstock, unsurprisingly, in 1873, that says nobody can use any drug or medicinal article or instrument for the purpose of preventing conception. That means, you guys, that condoms were still illegal in Connecticut in 1965. All right, so this case goes to the Supreme Court. The Supreme Court says that the law is invalid. It violates the Supreme Court because it violates the right to marital privacy. And this is the first case that establishes the right to privacy with respect to intimate sexual practices, right? And this is super important, this bit at the bottom here. They base this right to privacy on the 14th Amendment. They also cite the 9th and the 5th. But on the 14th Amendment, this is the big part. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So they cite the 14th Amendment, particularly this due process piece, that we can't deprive folks of life, liberty, or property without due process, and they claim that this law has done that. And so this law is struck down from the books. Interestingly, this law is used to base as a basis for the decision on this law. This case, which comes up in 1970. Now, those of you hopefully are familiar with this, only because it's a big one, and you should be. This is the case of Roe v. Wade. This is the case that the big case that essentially decided abortion law in the United States. So in 1970, a woman named Norma McCorvey, who goes into the case named Jane Roe, would like to have an abortion, but a Texas law has actually criminalized abortion, which means she can be charged with murder. She claims that law violated her constitutional rights. Texas law banned all abortions except those necessary to save the life of the mother. That issue is interesting, and we'll come back to that. She claimed her life wasn't endangered, but that she couldn't afford to travel out of state to have an abortion and had the right to terminate her pregnancy in a safe medical environment, and that her constitutional rights included that. So that was what the case was when it went to the Supreme Court. The Supreme Court ruled that law violated her constitutional right to privacy. That her right to privacy included her protected ability to make her decisions about her body and and then have them executed in a safe medical environment. They cited the 1st, 4th, 9th, and 14th Amendments as coming together to refer to what they titled a zone of privacy. That said that the zone of privacy included marriage, contraception, and child rearing, right? And they cited past cases. The big one they cited was Griswold versus Connecticut. So they said there's this precedent now that this zone of privacy protects decisions made about contraception and marriage and children and intimate practices. So it encompasses a woman's decision whether or not to terminate her pregnancy. So just so we're clear, according to the Supreme Court's read of these constitutional amendments, a woman's right to decide whether or not to terminate her pregnancy is covered by her right to privacy in those amendments. That's according to the Supreme Court, okay? Dang it. All right, that's all right. We're going to the next slide anyway. There we go. Okay, now, you may have heard, and what I do hear from some students sometimes is, okay, if the right to privacy protects our rights to life, liberty, and property, who is protecting the life, quote, of that fetus? Here's how the court approached that. The Supreme Court says that prenatal life was not within the definition of persons. Not within the definition of person. All right, y'all. It's almost just as bad as if I was there with you, isn't it? Here we go. Not within the definition of persons used and protected in the U.S. Constitution. However, they said that America's criminal and civil laws only sometimes regard fetuses as persons deserving protection. Culturally, some groups regard fetuses as people. No consensus officially exists. But basically, the Supreme Court's verdict on this is that they're not considered persons protected by the U.S. Constitution, but state laws, because they make decisions about having a, quote, a vested interest in life. That's what state laws, that's their purview. They can make decisions on that. There are certain state and civil laws in which states are allowed to consider fetuses people, but it varies on the situation. This is why we get various laws in different states about when an abortion is okay, right? And when a fetus is considered a person. So the way this shakes out, I just want to make sure you understand how bizarre this is. The way this shakes out is that different states, each state has a different decision about when a fetus is a person. A life begins at a different line, at a different time, according to which state you're in, right? That's how kind of weird and squidgy this all starts to get, all right? So, the next bit we want to talk about. All right. So Roe v. Wade. All right, so this is interesting because what it establishes is the rule of viability, right? And in 1970, what they say is that a fetus is viable after 6 months during the third trimester. And so before that, after the 6 month mark, a state can constitutionally protect a fetus because it's a person. It can survive outside the womb, right? As long as there are exceptions in those laws to save the life of the mother. So like if the mother's life is endangered, her health indicates that like she will die if she carries to term, there are exceptions to those laws. Additionally, because second and third trimester abortions present more risks, the state might regulate certain aspects of abortions related to maternal health and so on. All right, so this is the first time in history that we have the Supreme Court ruling on this notion of viability, when a life begins. And what they say is that essentially when a fetus is viable is that third trimester. This is important because it comes back to haunt us. It's still haunting us. All right, so hang on to that. Go ahead and take a little time out and click to the next video in a